Recording and also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Appeal of T.J., case number 24 AP 371. Representing the appellant, T.J., is attorney David Schlansky. Representing the appellee, the Department for Children and Families, is attorney Zachary Martin.
Thanks very much, and good morning, everybody. We'll hear from counsel for the appellant. First, of course, please, for the record, introduce yourself, identify your client, and then proceed.
Good morning, Your Honor. My name is David Schlansky. I represent TJ, the appellant. I'm going to reserve 1 minute, if I may. Basically, I want to rest on the papers, but I do want to point out one thing in this very brief hearing, which is the anachronism at core here. So the state is allowed to interpret statutes in ways that may be binding, but when it purports to make rules, engage in effective lawmaking by way of policy or rule, it has to be done by a proper mode, and it also has to be done in a way that exposes things in a chronology that makes sense. So there has never been an articulation of the who, what, when, where, other than just a lot of bad things that happened at non-specific times. When asked, what is the basis for this? The state has cited a policy that on its surface purports to bind the agents of the state as to their conduct. So the idea that this applies to the world at large is inherently implausible because those policies purport to bind the agency and its agents. But moreover, that policy was proffered as being the 2024 policy. So if one is going to be aware of what one is doing wrong, one is a child. The idea that everybody knows the law becomes an especially strained fiction when one is charged with knowing something that the hearing officer himself discloses as being something that is impossible to have governed. He cited the 2024 policy, again, categorically inapplicable, as to conduct that at the absolute latest could have occurred in 2019, and by the accusation, which again doesn't have any particularity or specificity as to time, place, and act, other than generally bad acts, could have been about a decade earlier. We're talking about a 5-year-old to a 13-year-old. So my respectful view is deference has its limits, and this is an extreme case where whether or not these things happened is something that my client vigorously contests, but he would have a very different case if he were charged with something where it was clear that the state has to prove that he violated lewd and lascivious conduct as defined in a way that's even coherent. There's much else in our papers, including as regards supposed accuser, who is sort of a notional accuser who had been proven to have made false accusations like this in the past, who was kept off limits, even though the allegation as to that accuser was live throughout the proceeding. It seems to me to be inherently unfair to say you can't have a go at showing that somebody has proven to be a liar in highly similar accusations in the past. Given the short time, I will rest and ask if you have any questions.
Okay, thank you. I don't see any hands. So we'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. My name is Zach Martin, and I represent the Vermont Department for Children and Families. Because the board's reference, thank you. Because the board's reference to the department's policy was proper, and because its exclusion of evidence related to HK was not an abuse of its substantial discretion, this court should affirm. This court has long instructed the board to rely on DCF policies as guidance in considering whether a substantiation should be upheld. And this has been reiterated as recently as 2022 in the In Re MV case cited in our brief, wherein this court noted with approval that DCF's own interpretation of the statutory subsection at issue aligned with the board's interpretation. And this court cited to DCF policy 56, I believe it was the 2020 version, of that. So the board correctly followed the court's repeated direction in this regard, and there was no error. I'll also note that unlike the appellant in MV, who argued that there was some daylight between what he pled guilty to in his criminal case and what the DCF policy required, the appellant here, his conduct, he's not arguing that it wouldn't have met lewd and lascivious conduct. And given the facts in the record, he couldn't show that because his sexual touching of his cousin included digital penetration that was coerced, unwelcome, and done without her consent, as noted in page 10 of our brief. So even if the board should have used some different definition of lewd and lascivious conduct that may have been in effect at the time that appellant was engaging in this conduct, there's no argument that his conduct wouldn't have met those definitions, which are all contained in the appendix filed as an attachment to our brief. In general, agency policies are afforded deference if they relate to matters within the area of their expertise, and that's true regardless of whether they go through rulemaking. In fact, the APA has a specific carve-out for these types of guidance documents. That's at 3 VSA section 835 subsection B, which indicates that the subsection is not intended to affect whether a court or quasi-judicial body gives deference to a procedure or a guidance document issued by an agency whose action is before the court or body. And if you look at the various versions of the policy at issue, policy 56, including the present one and the ones in effect in prior years, for example, those at printed case 47, printed case 50, they state that their purpose is to guide case determinations regarding reports of child abuse and neglect. As to the exclusion of evidence related to essentially uncharged conduct, the other younger cousin, as argued in page 13 of our brief, the hearing officer gave appellant a chance to ask for reconsideration of this ruling at the close of the department's evidence. In the event that the department's evidence somehow used the allegations from this younger cousin to prop up the allegations as to TM, but the department didn't introduce such evidence at the de novo hearing, and the appellant didn't ask for reconsideration of the ruling. So I would argue that that's a waived issue and this court shouldn't consider it at all. To the extent that this court does, the department's decision to not pursue the aspect of the substantiation related to the younger cousin made evidence about her irrelevant to the board's consideration. It's just an evidentiary ruling subject to an abuse of discretion, and it did not implicate confrontation because appellant doesn't have any confrontation rights in the context of this administrative proceeding. This court held that all the way back in 1997 in Passion against SRS, and the Lowell case cited by appellant is not to the contrary. In that decision, the Second Circuit outlined what categories of state proceedings warrant younger abstention: ongoing state criminal proceedings, state civil enforcement proceedings, and proceedings involving state courts performing their judicial functions. And the Lowell panel held that Vermont's substantiation process, while akin to a criminal prosecution, fell within the second abstention category of a state civil enforcement proceeding. The Lowell panel certainly didn't hold that respondents.
You have 1 minute. You have 1 minute, counsel.
Thank you, Your Honor. Certainly never held that respondents in these administrative proceedings had the same criminal procedure protections the criminal defendants do. And even if it had, this court, not the Second Circuit, has the final word on questions of state law like this. So I would just ask that this court consider the arguments in the briefs and affirm the judgments below. I'm happy to answer any questions if there's time.
Okay, I don't see any hands, so thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 35 seconds remaining.
Counsel?
Okay, I'll take less time than that. So it's scurrilous, the allegation about digital penetration. It was not found by the tribunal. So that's citing something that is not in the decision. The idea that what the tribunal did say is that it was applying a 2024 policy. So what the state doesn't address is the impossibility and anachronism of this. So unlike other prior cases, we're talking here about something that there's no attempt by the state to show identity with a prior interpretation by the agency that's identical. In fact, it's very unclear when the supposed conduct happened, and the state seems to concede that prior to 2015, there wasn't even any putative attempt by the agency to articulate what lewd and lascivious was. And to the idea that everybody knows, that's not good and sufficient, and also it's certainly not good and sufficient for a child. The idea of uncharged conduct is sort of a tell, because it wasn't uncharged conduct. Right up until the decision, it was alleged that this second accuser was a victim. And that was part of the main thrust, if you will, of this whole case. And it was only later that there was a sort of sua sponte dismissal as to her. But that was a live accuser who my client was disallowed to address in any way. And that would have shown that there was falsity throughout this. So my client respectfully requests that the court overturn this.
Okay, your time has expired. Thank you very much. Please call a conclusion of the hearing.
Thank you.